We feel this briefing is especially timely as SJ Res 1's companion bill, HJ Res 17, passed through the House of Representatives just last Wednesday during Women's History Month. Please find in the chat a link to background materials to accompany today's discussion. This briefing is also being streamed on Facebook Live and recorded. We are asking all participants who are not speakers to mute during the program. I am now pleased to introduce the ERA Coalition's President and CEO, Carol Jenkins, who will welcome and introduce SJ Res 1 co-lead sponsors, Senators Cardin and Murkowski. Thank you.
Thank you so much, Bettina, and thanks to you all for being here today. And so many great thanks to Senators Cardin and Murkowski for their bipartisan efforts to remove the time limit on the ERA. I am always so moved by the joint op-ed they wrote for the Washington Post in 2019, where they said, "We come from different ends of the political spectrum, but we agree that this needs to change. Women compose a majority of the American population, but continue to be underrepresented in government, elected office, the courts, and the business world. A level playing field should not be a euphemism, but rather a reality for women and men from Anchorage to Annapolis and everywhere in between. Equality of rights under the law should not be denied or abridged by the United States or by any state on account of sex, as the amendment says." The ERA Coalition is composed of more than 120 organizations across the country. Our partners represent millions of people who believe in and are working every single day for equality. Our Constitution does not now prohibit discrimination based on sex. The Equal Rights Amendment provides the necessary fix to a document created by framers who were mostly slaveholding, land-owning men who left out of consideration both the enslaved and the indigenous and also the women. They could not imagine the America of today, but knowing what they did not know, they created the amendment process. The Constitution has been amended 27 times so far. The ERA will be the 28th amendment, the 28th time that a fix was required to assure unforeseen rights and protections. For clarity, the ERA has already been passed. That happened in 1972 by 2/3 of Congress. It has already been ratified. Virginia became the 38th and final state required on January 27th of 2020. All of the requirements set out by Article 5 of the Constitution have been met. At issue today is the time limit inserted only into the introduction of the amendment by Congress. It is not what the states voted on. By passing SJ Res 1, the Senate will remove the time limit. And as you may know, the House of Representatives did that last week by a vote of 222 to 204, effectively dissolving the time limit in the House. The Senate needs to do it now. On that same day, the House passed the reauthorization of the Violence Against Women Act. And the alignment of those two measures could not be more perfect. The ERA is the constitutional underpinning of VAWA, not subject to constant and unpredictable renewal. The ERA would establish permanent protections against violence, no matter what the sex of the person who experiences it. We only have to look at the Atlanta killings last week to know that we have serious and devastating violence against women that must be curbed, and rights, justice, and protections for survivors that must be provided. As we address Equal Pay Day tomorrow, we know what a sad commemoration that is. Numbers that have not changed, infuriatingly stubborn. It still takes a Latino woman almost a year to make what a white man made the previous year. The ERA would be the permanent constitutional underpinning for equality, for fairness, and for safety in the workplace. I recently had the opportunity to write with the esteemed Dolores Huerta and Eleanor Smeal an op-ed on the subject of the ERA and the time limit. They each have been waging this heroic fight for a half a century for the ERA. And what we said was, in comparing the 1918 epidemic that almost derailed the women's right to vote, women persevered back then 100 years ago, but our current pandemic shows us our women by the millions out of the workforce, some never to return to their 2 or 3 low-paying jobs it took to sustain their families. And we say that America is ready for the Equal Rights Amendment. The vast majority of Americans across demographic and party lines agree that women should have equal rights with men in this country. In a 2020 Pew Research Center survey, more than 9 in 10 U.S. adults said it is very important, that's 79%, or somewhat important, another 18%. Fully 78% of U.S. adults, including majorities of women, men, Republicans, and Democrats, favored adding the ERA to the Constitution. And we believe that America is ready for passage of S.J. Res. 1. Bettina, I throw back to, we understand that Senator Cardin has joined us. We are so thrilled to have him with us. Senator Ben Cardin is the senior United States Senator from Maryland. First elected to that seat in 2006. He previously represented Maryland's 3rd Congressional District from 1987 to 2007. And before that, Senator Cardin served in the Maryland legislature, including as Speaker of the House. He is co-lead sponsor of S.J. Res. 1 to remove the time limit on the ERA, and certainly, Senator Cardin, one of our great champions. Thank you so much for being here.
Well, to Carl Jenkins, thank you for your extraordinary leadership on behalf of equality and fairness in our state. Really appreciate it very much. To Bettina Hager, thank you for your leadership here today and bringing us all together. It's great to be here with Lisa Murkowski, my friend and colleague. That is correct. The two of us have different views on many issues, but not on the Equal Rights Amendment. We are joined together, Democrat, Republican, from Alaska to Maryland, to urge the Congress to eliminate the time limit on the Equal Rights Amendment. As Carol has pointed out, the number of states that ratified the basic Equal Rights Amendment that was submitted by Congress. There was no time limit on this. There have been constitutional amendments that were ratified as recently as just a few years ago that involved the Bill of Rights, over 200 years in getting passed. So there is no time limit, but Congress has the right to set a time limit. Congress has the right to extend that time limit or eliminate that time limit. And that's what this resolution does. And I want to thank Senator Murkowski. This should not be a partisan issue. This is a matter of basic fairness, what should be done. This is Women's History Month, and International Women's Day was March 8th. The 2021 theme for International Women's Day is Choose to Challenge. I'd like to underscore that, to me, is what John Lewis told us, to get into good trouble. Now is the time to complete the work. And I was reading some of Abigail Adams' letters to her husband when they were developing the Constitution. And she said, you better take care of the ladies. If you don't, there will be a rebellion. Well, we are rebelling against the provision that we do not have in our Constitution, the protection of Equal Rights Amendment. Quite frankly, most people in this country think it's already in the Constitution. But as has been pointed out, as Justice Scalia said, there is nothing in the Constitution that requires discrimination. But if you ask me if there's anything in there to protect it, the answer is no. We need to correct that. And it was former Supreme Court Justice Ruth Bader Ginsburg who said, every constitution written since the end of World War II includes a provision that men and women are citizens of equal stature. Ours does not. If I could choose an amendment to add to the Constitution, it would be the Equal Rights Amendment. I would like my granddaughters, when they pick up the Constitution, to see that notion that women and men are persons of equal stature. I'd like them to see that in a basic principle of our society. We have the chance to get this done this year. I want to thank Senator Schumer. It's by no accident that this is Senate Joint Resolution 1, the priority to get this done in this Congress. So here's the challenge, Carol. This is a briefing for the Senate. We need votes. We need you to identify senators that we can get to support this resolution, and that we will work with their constituency back home and we will work with the members of the United States Senate here in Washington, and let us get the necessary votes to get this accomplished. So I hope that we can find 65, 70 senators who will support this so we don't have to worry about procedural hurdles. So let's work with that in mind, and there's really no reason not to vote for this. And I think that if we develop a strategy where we share information, we get the local groups to lobby our individual senators to support us, we reinforce that by our conversations here on the Hill, we can increase our numbers. And that's the charge I have to each one that's on this call. Help us develop the list of senators who are not yet on this resolution and not yet announced their support for this resolution, so that we can get the necessary votes, so that Senator Murkowski and I can go to our leadership and say, look, we got the votes, let's bring it up, let's get it done. And at long last, let us be proud that the United States once again is leading on an issue by what we do, not just by what we say, by making sure our basic document protects the equal rights of all of our citizens. Thank you for being here for this briefing, and thank you for your help in getting this done.
And thank you so much, Senator Cardin. We understand that Senator Lisa Murkowski is with us. She is the senior United States Senator for Alaska, having held that seat since 2002. She previously served in the Alaska State Legislature from 1999 to 2002. She is co-lead sponsor of SJ Res 1, the resolution to remove the time limit on the ERA. Senator Murkowski.
Carol, thank you. Thank you for your leadership, Senator Cardin. It's good to follow you in comments, but to lead with you on this critically important initiative. Thank you for that. I also want to recognize Bettina. I want to just all the folks at the Equal Rights Coalition for the dedication, the effort that you have made, the advocacy that has been so long and ongoing. To Steve Anderson, for starting the GOP for ERA organization, taking on the hard, perhaps relatively thankless task. We appreciate what you are doing. And a special thanks, I want to give a special shout out to my Republican colleagues in the House who have taken this vote for equality. But really a genuine thank you to those people who've been really working hard, working on the ground in various states. You're going out to your state legislatures, you're getting local representatives on board. You've been doing it for years, and that's the reason that we're getting closer and closer again. And to Senator Cardin's point about the optimism that I think that we're feeling, we're here at the start of a new Congress. We're taking yet another shot at the Equal Rights Amendment becoming fully ratified as part of our Constitution. And again, when you think about optimism and where we are, this is the first Congress to begin with the necessary 38 states having ratified the amendment. So we should be hopeful there. We've got that momentum. The bill number, as Senator Cardin has noted, demonstrates the priority, which is greatly appreciated. And again, the early action by the House, I think, is yet another reason for optimism. It gives us here in the Senate a little more time to work on our colleagues and find some additional Republican support. So for those staff who are on this briefing, your mission is to go out and talk to your bosses. We need some help here. I think we know that. If they haven't, if they have already co-sponsored, that's terrific. That's great. But also convince them to speak to other members who have not co-sponsored. And really, we need to ask if members haven't co-sponsored, really, why not? Why not? If you're a man here, you need to ask. You need to ask if your boss is a man. Ask him if he wants his wife, his daughters, his mother to be protected by the Constitution. We recognize that a woman's dignity is not defined by her relationship to anybody else, and that dignity should be recognized, appreciated, and respected, independent of any other measure. And if your boss is a woman, ask her essentially the same question. We're talking about equality here, and I just keep asking myself, why exactly should the Equal Rights Amendment be so controversial? So I know Steve will have an opportunity to speak about historically, the Republican Party has been fully behind this movement, how he's trying to bring the party around to demonstrating that support again. But I think Republicans should be reminded equality was a founding ideal of this party. We need to return to that. So I thank everyone for their individual efforts, their respective efforts that truly are making a difference. We need to seize the momentum. We need to move forward now. We need to build our numbers, and we will do that with the enthusiasm that is generated by so many of you that are on this call today. So thank you for that, and look forward to working with you all to make a difference.
Thank you so much, Senator Murkowski, and thank you for your leadership and your hard work on this resolution. SJ Res 1, women #1 this year in the Senate. Thank you so much. I cede my time back to Bettina Hager, our esteemed DC Director. Bettina.
Thank you so much, Carol. And I want to echo how thankful we are to both senators for their leadership and commitment, and for sharing introductory remarks with us today. So I am now pleased to introduce our panelists. You have heard from Carol, but I want to give a little bit more background as to who this amazing woman is. Carol Jenkins is president and CEO of the ERA Coalition and Fund for Women's Equality, sister organizations dedicated to the adoption of the Equal Rights Amendment. She was founding president of the Women's Media Center, a national nonprofit organization created to increase coverage and participation of women in media. She is an advocate for human, civil, and women's rights, an award-winning author and Emmy-winning former television journalist, who currently hosts a 3-time New York Emmy-nominated interview show, Black America, on Cooney TV. We will then hear from Linda Coberly. Linda Coberly is the Chicago managing partner of the law firm of Winston & Strawn and serves on the firm's executive committee. She is a partner in the firm's litigation department and chairs its appellate and critical motions practice. She is a constitutional and appellate lawyer, clerked on the Supreme Court, and serves as chair of the ERA Coalition's legal task force. And following Linda, we will hear from our co-host, former Illinois State Representative Steve Anderson. During his last session in the Illinois House, Representative Anderson was the chief Republican sponsor of the Equal Rights Amendment and successfully passed the amendment, making Illinois the 37th state to ratify the ERA. Since passage of ERA in Illinois, Representative Anderson has traveled the country advocating for passage in additional states. In 2021, he also formed Republicans for Equal Rights in order to further advance the Republican Party's advocacy for the ERA and equality for all. I want to thank all of the panelists for being here. Carol, I want to thank you for your remarks at the beginning. And I'm going to move to Linda and ask Linda if you could give your remarks and discuss why Congress can vote to remove the time limit and what that means.
Absolutely. It's really a pleasure to be with you all today. And I'm happy to talk about this issue. It's been a huge thrill for me and my law firm to be involved with the ERA. And it's actually one of our first real forays into matters of politics, but it's something that our leadership really feels strongly about. So we're really proud to be part of the ERA coalition. So you may be wondering, why are we talking about the ERA? And that's a great question. A lot of people do believe today that the ERA is already part of the Constitution, including lawyers. And it's kind of a rude awakening when they hear, no, it actually didn't make it yet into the Constitution. So why are we still in Congress? Well, we're there because we really have an unprecedented situation. The Congress in 1972 imposed a time limit on ratification. I'm going to talk in a second about exactly where that time limit is located and why that matters. But the time limit was originally imposed in 1972. It was extended by a simple majority of Congress in 1979. And the House has now voted to remove it altogether. And the reason that this is still a topic that Congress can deal with is because of the placement of the time limit. So from the beginning of our nation, there were no time limits on ratification or on amendments. There were no time limits at all until the beginning of the 20th century. In fact, the 27th Amendment to the Constitution was proposed by James Madison at around the time of the founding and took 203 years to become part of the Constitution. It was in the early part of the 20th century with the Prohibition Amendment, actually, that Congress began the practice of imposing a time limit on ratification. But for most of the 20th century, it placed the time limit in the text of the amendment itself. What that meant was that really the states were voting not only to change the Constitution, but also to impact the ratification process under the Constitution. The ratification process is described in Article 5 of the Constitution, and it doesn't say anything at all about time limits. In fact, what it says is that an amendment will become valid for all intents and purposes when ratified by 3/4 of the state legislatures. Well, that's happened now for the Equal Rights Amendment. That criteria, the only constitutional criteria for an amendment, has now been satisfied. What Congress did beginning in the middle of the 20th century and with the ERA is to move the time limit and put it, instead of in the amendment itself, it put it in the preamble. And so when the 1972 Congress voted overwhelmingly to send the issue to the states for ratification, it concluded that the period for ratification would be 7 years. It didn't say the ERA would expire. The time limit is not an expiration provision. It is not a sunset provision on the ERA itself. It is simply a time limit on the period for ratification. And because that time limit appears only in a joint resolution of Congress, Congress reserved for itself the power to change it later on. The issue of Congress's power to change the time limit was the subject of extensive discussion in Congress in the late 1970s, and Congress ultimately decided that it could change the time limit, and it voted to do so and extended the time limit by 3 years. What the current resolution does is remove the time limit altogether. And in fact, the language of the resolution matches the language of Article 5 almost entirely. Basically, the resolution today would remove the time limit, and it would make clear that the process and the time period, or no time period, for amending the Constitution is just what's set forth in Article 5, which says that the amendment becomes valid when ratified by 3/4 of the states. So it's a straightforward proposition. The amendment or the resolution that the Senate will be asked to consider and vote on is very simple and very straightforward, and it simply removes the time limit. So with that basic explanation, I'm going to turn things over to my fellow Illinoisian, Steve Anderson, who we are really thrilled to have working with us in support of the Equal Rights Amendment.
Thank you so much, Linda. Thank you to Senator Cardin and Senator Murkowski for their kind remarks. I could not agree with either of them more. This is a bipartisan issue, and it's important to note it has always been a bipartisan issue. Starting in 1972, the Republican Party platform contained passage of the ERA as one of its fundamental planks. And as I believe Carol noted, since that time, the polling on the subject has not changed. Republicans in vast majorities favor the Equal Rights Amendment, favor passage of this. So it is important to not seed the concept that this is somehow one party driven. It is not. And in fact, that is why I was so proud to pass the ERA in Illinois as the senior Republican on the bill, the senior sponsor on the bill. And also the time I have now spent since then working amongst the various states to finish this, because quite frankly, for me, passing in Illinois was great, but it's not done until it's all the way done. And in 2021, we created GOP for the ERA or Republicans for equal rights. The point there is that we have to refresh that knowledge that this has always been a Republican principle and always will be. Now, one of the things that I oftentimes heard about as an objection when I was working this in Illinois is, well, we already have the 14th Amendment, and that takes care of it. Everybody's got that, so problem solved. We don't need the ERA. And there is very few things that could be further from the truth than that. You could take it from the simplistic point of view is if that were true, we wouldn't have needed the 19th Amendment that granted women the right to vote. But let's go a little bit further. Let's look at what the case law actually says about the 14th Amendment and how it relates to women's rights. We have to remember that the 14th Amendment was developed not for women's rights, but for the rights of African Americans, of the population that had at that time recently been freed. And the whole point was a focus on them. And that is right and correct. And in doing that, the court has looked at it very strictly. In fact, the Supreme Court, established standards for how we can evaluate whether a law violates the 14th Amendment or not. And when we talk about race, they have imparted really a three-part test because it is not the Supreme Court's job to decide if they like a bill or a law. It's their job to decide if it comports with the Constitution. And so their three-part test is very strict, hence the word strict scrutiny that some of you or all of you may have heard. Step number one, is it a compelling state interest? Something that is so important that it justifies allowing some element of discrimination to occur. That's huge. Number two, however they drafted this law that is now being challenged, has it been drafted narrowly to achieve only the desired result? If we're going to allow some form of discrimination to occur, it better be tiny, it better be narrow. And number three, do we do it in the least restrictive means possible? In other words, if we're going to infringe on somebody's rights, again, it better be just the barest touch to allow that to happen. And there's a fourth element. It is presumed invalid. That's critical to understand, that when laws come before the Supreme Court, somebody bears the burden of proving their case. And the burden is on the government to prove that they can justify that they are going to be allowed to do some limited discrimination, not in violation of the 14th Amendment, but under an exception. That's race. And I can tell you what I just described, I think you all would recognize that's almost impossible to meet, right? Can you envision a circumstance where that would be acceptable? I can't, honestly, which means effectively as to race, there is no license to discriminate under the 14th Amendment. Now let's compare that to sex-based discrimination. The standard is this, that it substantially relates to an important governmental interest. That's it. No presumption of invalidity, no narrowly achieving its aims, no least restrictive means. That's it. Just that it substantially relates, or, we got a really good reason for this. That's it. That's all it takes. And now you can overcome objections based on the 14th Amendment, and you can discriminate against women. So anyone who tells me that the 14th Amendment solved our problem is not living in the same reality that I do. So we absolutely need it. Don't forget it. The 14th Amendment doesn't do it. But the other thing that I want to speak very briefly on, and then I'll conclude, is that the ERA reflects Republican core principles. What are those? They are things like individual rights and individual responsibilities tied together, that we believe strongly in the ability of individuals to chart their own path. That's what the ERA does. It promotes women to the point where they can chart their own course. They can succeed or they can fail on their own merits. Number two, it's about limited government. We are the limited government party, I believe. I think we still are. If we are, then the ERA fits that because it's not creating new rights. It's simply saying don't discriminate against women. It's what I'd call a restrictive amendment. In other words, it does not add new things to the Constitution. It simply says you can't do something, i.e. discriminate. And then last, of course, is we are about business, right? We're about our economy. It's the economy, stupid. Well, those words apply here as well. All data, all research indicates that when women are in the boardrooms and the courtrooms and the workrooms of America, and they join with men and with people of color and with the LGBTQ community, our economic engine goes up. This is all about the economy. These 3 points are core Republican principles. And that's why I fight so hard for this, because it will elevate all of us, not any one particular group, all of us, to an opportunity to make America just the place it has always been, wonderful, but better, because we finally enshrined it in the Constitution. We've made great progress, but this is the next step. And with that, I thank you all and turn it back over probably to Bettina.
Thank you so much, Steve. And as a reminder, I want to remind everyone that we are including the materials for today's briefing in our chat. I saw also the link to the website for GOP for ERA if you're interested in learning more about Steve's work and what he just spoke about. I'd like to start with just a few questions of the panelists and then open to questions from Senate staff who are attending. We thank everyone who is joining, but for purposes of this event, we're asking questions be prioritized for Senate staff members. And to the Senate staff members who are here, please just use the raise hand function to indicate you have a question you would like to ask. So my first question is going to go to Carol. So Carol, the COVID-19 pandemic has further highlighted and exacerbated inequalities that continue to persist in our country, particularly across gender, race, and class-based inequalities. As our country continues to embark on economic and social recovery from the COVID-19 pandemic, how do you see the need for the ERA fitting into this conversation?
Thanks, Bettina. Well, we certainly have seen our women finally in this country, is the one thing I will say. For those who work in the field of poverty and sexual aggression, domestic violence, all of the kinds of things that many of us work on, many in our country did not know about it. Hunger. Most people never concentrated on how many hungry people there are in our country. So for me, what the Equal Rights Amendment would do is to put into place the fundamental constitutional floor and bearing and recognition for the fact that we need to change things, and we need to change them permanently. We have so many bills and acts that, as we're fighting with VAWA to get that reauthorized again, we shouldn't have to do that. We shouldn't have to worry about, as we are eliminating half of the child poverty in the rescue plan that's going through, we shouldn't have to worry about having to do that again next year. There should be things that are permanent, that state what our principles are in this country. And I believe that the Equal Rights Amendment would provide the ability to do that. So we wouldn't have to be at the whim of necessary things in our lives being diminished or done away with, depending upon who was sitting in Congress at a particular time. So let's go for permanence and for an understanding of equality. And I think that that's what the impact would be. We should not, now that we are visible, we should not become invisible again. And the whole caregiving issue is especially important, and not to assume that we're only talking about mothers taking care of children. We're talking about women and men who are taking care of not only their children, but their parents, especially during this pandemic that we're in the middle of. Bettina.
Thank you so much for that, Carol. My next question is for Linda. So, Linda, the DC District Court recently came out with the decision to dismiss the case brought against the archivist by the attorneys general of the recently ratified states of Nevada, Illinois, and Virginia. I know there's a lot of confusion out there as to what this means, but you've written that it makes congressional passage of the time limit removal bills all the more urgent. Can you explain that and also touch on how this strategy is constitutionally supported?
Sure. So let me first just lay the groundwork for the lawsuit. Under the Constitution, the only entities that have a role to play are really Congress and the state legislatures, and that's it. The president doesn't have a role. The executive branch doesn't have a role. So once under Article 5, once the amendment is ratified by 3/4 of the state legislatures, it is effective and part of the Constitution, period. Federal law creates a ministerial role for the National Archivist. Essentially, the archivist is the person who is supposed to keep track of the ratifications, receives the mail, receives the ratification certificates from each of the ratified states, counts them up, and when the requirements of the Constitution are met, the archivist is supposed to, under federal law, publish the amendment with his certificate as a valid part of the Constitution. Some litigation began last year, immediately before and after the ratification by Virginia, which is the 38th state. And one of the lawsuits was a lawsuit brought against the archivist by the attorneys general of the last 3 ratifying states, Virginia, Illinois, and Nevada. And that lawsuit alleged that the archivist, who was at that time refusing to certify or publish the amendment, should be forced to do so. It's called a mandamus lawsuit. There was a briefing on that issue. A number of states that opposed the ERA were permitted to intervene. And so the litigation has been in briefing for about a year. And recently the court issued its decision. It held 2 things. First of all, it held that the states who brought the lawsuit did not have standing under the Constitution to sue the archivist right now for mandamus relief, because according to the court, at the end of the day, whether the archivist certifies the amendment doesn't really make a difference. The court also held that even if there had been standing by the plaintiff states, the time limit is in effect. It is still on the books, and it does effectively block the ratifications by the last 3 ratifying states. So now, the court specifically did not resolve a number of additional issues, including it didn't resolve any issues about whether a state can rescind a prior ratification. It also didn't resolve any issues about whether the Congress has the power to change the time limit after the fact. It did not specifically decline to reach that issue. So what does that mean? Well, first of all, it is important to note that judge's view of the time limit as it stands today is not going to be the court's last word on the subject. Whether it's on appeal or in the lawsuits that will be filed beginning in January of next year to enforce the ERA after the 38th Amendment, other courts will need to decide whether they agree with Judge Contreras on the issue of the time limit. But the more important issue is the one that we're here to talk with you about today, and that is Congress removing the time limit. In essence, what the district court's decision does is kick it over to Congress to decide whether it believes that the 1972 time limit should remain in effect. If Congress had the power to impose a time limit and limit ratifications, it also has the power to remove the time limit. In fact, it reserved that power for itself by placing the time limit in the preamble rather than putting it in the text of the amendment itself. So that's why we're here, and it's quite consistent with what the district court held in that case. Now, I've heard people say sometimes, how could this be constitutional? How could it be constitutional to remove the time limit? Well, I guess the first question is it constitutional to put the time limit in the first place? And that's one of the questions that the court was dealing with in the litigation. But for your purposes, the question is simpler. If Congress had the power to put in a time limit, then it also has the power to remove the time limit, because we know that one Congress can't do something that binds another Congress. So there is nothing in the Constitution that prevents the bill that is before the Congress today. There is nothing in the Constitution that limits Congress's power to change a time limit once it has decided to place a time limit on ratification. And that's what we are asking the Senate to do.
Thank you so much, Linda. And my last question to the panelists, and then I do encourage everyone here, especially the Senate staff, to ask your own questions, any questions you may have, is for Steve. So Steve, you touched upon this a little bit, but I just wanted to give you an opportunity to maybe elaborate a little bit more, especially, as to why you felt it was necessary to create the new organization GOP for ERA. Although historically the Republican Party was in the forefront of support for the Equal Rights Amendment, over the last few decades, the perception is this is no longer true. Can you talk about how the ERA continues to be an issue that Republicans do and should support, and how it's aligned with your and their core values, which I know you spoke a little bit about, but just wanted to ask a little bit more detail there.
Sure, thank you for that. I appreciate it. And it is important to recognize that times do change. 1972 is a long time ago. I was 8 years old in 1972 when this got started. So there are differences. And what I prefer to focus on right now is where the Republican Party is going. Quite honestly, we have been maligned in recent years. We have been accused of everything from being racist to misogynist to you name it. And while there are individuals who are guilty of that, I believe, as a party, it is unfair and untrue. I remain as ever strong and faithful a believer that what we look for is that individualism, that bright future for every person to have that opportunity. Well, if we would like to rehabilitate that image amongst some people, I cannot think of a more appropriate way to do that than to find our previous support again in our legislatures for the ERA. Think about it. Someone earlier mentioned that more than 50% of the population is women. How about the Republicans do something that would really please more than 50% of the population? That's the ERA. That's what we are doing here. And again, it reflects our core values. But I want to add one more concept to that. Think about this. I told you why the 14th Amendment addresses race-based discrimination better. And everything I told you, I believe, is accurate. But if you asked me a different question, if you said, so Steve, does that mean because we have strict scrutiny that there's no discrimination against people of color in the United States anymore? I think you would all laugh, right? Because there is. So even strict scrutiny doesn't work. It's not enough. And so the ERA at least boosts us to that level and gives us that opportunity to work together, hand in hand, to fight for these equality notions. And that is a Republican concept. By the way, it's a Democratic concept too. I'm not suggesting otherwise. But it is important to recognize that this is something that Republicans believe in wholeheartedly. And I'll tell you, in my state, in the great state of Illinois, when we passed it, 25% of my Republican caucus, in spite of intense objection from a lot of different groups, voted for it. It wasn't one or two. It wasn't me. It was me plus 25% of my caucus, something I'm very proud of. And that's why we've started GOP for the ERA in Illinois, because with that strong base of support, we're going to reach out and we're going to go to those other states, as I've already been doing, but now with renewed focus, to make certain that we have the opportunity to communicate the Republican message on this, and we can change the narrative. We can change this narrative that Republicans are somehow against women. It is not true. It has never been true. And we're going to make sure it's not going to be true in the future. So thank you.
Thank you so much, Steve. So now I want to open it up to questions. Do we have any questions from the audience? They said we are prioritizing questions from Senate staff. However, if there are questions from the audience and we have time, we'd be glad to address those as well. So if you have a question, please just raise your hand. I don't see any of yet, which I'm going to give as an amazing testament to the three panelists and the material that you provided. I wanted to give you an opportunity to sort of to wrap things up and maybe even comment on, and just give your comments as to why right now, 2021 is the time for this to get done, why you think that it can get done, and how the Senate, especially the Senate staff, what can they bring back? What message should they bring back to their bosses, to energize those who are supportive and to convince those who might be on the fence? So I will start with you, Linda.
Well, I think the question that's going to be put to the Senate is essentially, do you think there should still be a time limit on the Equal Rights Amendment? And I don't know why the answer would be yes. We now have overwhelming support in this country to include the ERA in the Constitution. And that's broad bipartisan support. There were, as Steve explained, there were bipartisan votes in every one of the states who ratified most recently. And it is a human being issue. It doesn't create new rights. It doesn't create broader rights. It simply puts a heavy burden on the government before it is able to discriminate on the basis of sex. It's not a lot to ask, and yet it would be incredibly important. And it would put the United States finally on a par in this respect with every other country that has developed a written constitution since World War II, all of which have equal rights guarantees in them. So this is a really important issue. I do agree with Steve that this is a way for senators on both sides of the aisle to demonstrate that they care about women and they care about equality. And it really doesn't have to go any further than that. It's a very simple thing to do. It's a simple statement. And, I think I don't imagine that the senators you work for want to be on the side of maintaining a time limit on the Equal Rights Amendment. And that's really the question that they're going to be faced with asking. There is no constitutional impediment to removing the time limit. In fact, the constitutional authority for it being there in the first place is in question. And Congress can vote today to remove the time limit, and we ask that you do.
Thank you so much, Linda. And we do have a question from Mary Pollock, who has raised her hand. If Mary, you want to unmute and ask your question?
Okay. My question is, tomorrow is Equal Pay Day for all women's Equal Pay Day. My question is, do you think the Equal Rights Amendment would help us toward achieving pay equity and reducing gender inequalities in pay and in the workplace?
Go ahead, Linda, and then I'll add my 2 cents.
So we'll go to Linda, who will give probably the very good legal background, and who will give.
Yes, you can count on me for the legal answer. So the Equal Rights Amendment, if you look at its text, it's pretty specific, and it talks about discrimination by states and by the United States. So what that does is, in the plain text of the Equal Rights Amendment, there is what some people might call a state action requirement. And what that means is that the Equal Rights Amendment is focused on discrimination by the government. Now, that's really important, and I do think it would have an effect on equal pay, because first of all, the ERA, making it part of our Constitution, changes the conversation, right? It elevates the cause of sex equality to a different level in our national conversation. It's really, as Ruth Bader Ginsburg said, even if it were just symbolic, which it's not, it's a really important symbol. So I think that's very important. But also, even just an equal rights amendment that applies in the public sector to government can have a very substantial impact on pay equity. For example, Many of our, it would certainly apply in the military. It would apply to teachers. It would apply to state workers. It would apply to municipal workers, many of whom in all of those categories are women of color and who face intersectional discrimination that is magnified by both their race and their sex. And so including a prohibition on sex discrimination in the Constitution would be able to drive equality in all of those fields and would have effects bleeding into the private sector as well, just simply based on competition. Carol?
Mary, thank you for your question. That's exactly what I would have said. No, but I'm just going to add to that after 100 years in this quest from 1923 when Alice Baum first introduced it, so almost a full century, what I believe is that so many of our persistent problems, including pay equity and many, many other things, lie in our Constitution. We've tried everything else. If you can talk about the trillions of dollars and the time and the energy that we've put to trying to solve sexism and racism. And the reason it hasn't worked, we've made some progress for sure, but the reason we still have these immense problems is that it's built into our Constitution. When you write a playbook like that and you're not thought of, you're not included, it has been a persistent issue of just sheer recognition. We still are not recognized. And so I think that once we have the Equal Rights Amendment, we will have gone to the heart of the problem. And that is our Constitution needing to be fixed so that we are included. And I think we'll see a vast number of improvements. Now, I also will say that the ERA may not fix everything, but the question, just as Justice Ginsburg would have said, it may not be the perfect thing, but we need it. Does it have to solve every single problem? I don't think so. I think that it will take us a long distance to getting where we want to be, and that is just sheerly on an even footing. It is not supremacy, it's even footing. So that's why we're working so hard for the Equal Rights Amendment.
And if I can add one point to Mary's question, it is important to recognize it's not a panacea. It is not going to fix everything. We will still need federal laws to address inequities. We will still need state laws to address inequities. So that's what I'm trying to say, and I would repeat it for the Republican staffers in particular who might be in the room, is that it doesn't do a bunch of things that we're not anticipating. It is a state action restriction. It is not about everything else on the planet. And in fact, so often I have heard questions about what about this horror story or that horror story? The reality is that we've had equal rights amendments at the state level for 50 years. And all of those horror stories, they haven't happened. If they were going to happen, they would have happened in states like Illinois and others who have always had it. And we still have to do what I said. We still have a pay equity law. We just amended it recently. We still have to address all those things. So the ERA won't fix everything, but it's a darn good start.
All right, we have another question from Andrew Guernsey from Senator Steve Daines' office. Andrew, if you want to unmute and then ask your question.
Thank you. So my question is, and it alludes to what Steve just was talking about, on the issue of abortion. We know the New Mexico Supreme Court interpreted their state ERA to strike down the state Hyde Amendment for all, quote, medically necessary abortions. But medically necessary has been interpreted to mean all abortions. So what restrictions on abortion could survive strict scrutiny under the ERA, including ones that the court has upheld under Roe v. Wade, in the Casey decision and the partial birth abortion ban? Thank you for your time.
Thank you. Linda, you want to start?
Sure. So there, as Steve mentioned, there are equal rights amendments in now half of the state constitutions. And what we have not seen is widespread rulings by courts really engaging with those with those state ERAs as a way to strike down various kinds of restrictions. You're right that there's a decision in New Mexico. There are a handful of other decisions that have all dealt with the issue of whether there can be a definition of medically necessary that differs essentially for men than it does for women. And so that's really going to be the question. I mean, the reality is we have a federal recognition today that our federal constitution protects reproductive rights. And that happened without the ERA. And I have never heard anybody really articulate a way that any restriction on abortion that has survived under Roe v. Wade would not survive under the ERA. It's just an analysis that I've never really heard anybody be able to put together. I've heard a lot of kind of dire predictions, but those dire predictions don't seem to be supported by the very small number of decisions under state ERAs. And I've not heard a good explanation for why a particular restriction would be impossible under the ERA when it is possible today under Roe v. Wade. Steve, do you want to? I know that this is an issue that you think a lot about.
And Andrew, I would commend you to my website. I have a white paper on the question of the relationship between abortion and the Equal Rights Amendment. I would take issue with a couple of things on that, though, because there are the two cases, one out of New Mexico, and I believe the other one's out of Connecticut. There are a great number of other cases out of other states that hold the way that I prefer, being a pro-life Republican, is that there is no connection or relationship with them. So there's no guarantees on which way a U.S. Supreme Court might hold on that. But if we look at the narrow question in the case in New Mexico, it was about how they define medical necessity. And it's also in the more limited scope of COBRA coverage, in other words, Medicare, Medicaid, because Medicare and Medicaid regulations require the medical necessity standard. That is not true of private insurance. So private insurance has always had the ability under state law, because private insurance is generally almost completely dictated by private or by state law governance, not by federal law governance. They have always been able to deny coverage in the private sector. So we're talking about a pretty narrow scope when we're even discussing the issue. And I would push back respectfully on the concept that medical necessity, as that court read it, means anything. It meant that if a doctor determines that there's a medical necessity, then it would be covered. So I do not in any way accept the proposition that an elective abortion is medically necessary in the state of New Mexico or anywhere else. But as I said, the GOP for the ERA.com website has some resources, and one of them is a white paper on this question of connectivity.
Thanks.
Thanks so much to both of you. So we are about 2 minutes out of our hour time mark, but I want to thank you all for attending. I want to thank the panelists, and I just want to ask the panelists to end with one statement as to if you had a 30-second speech to convince every senator in this Congress to why we need the ERA, why it's so important to vote on this, what would you say? I'll start with you, Carol.
I would quote Jackie Spear, who said last week after the resolution passed, women want in. We want in the Constitution. It's as simple as that, so that we are not able in this country to discriminate based on one's sex, whatever that sex may be.
Mm-hmm. Steve, you want to have your next 30 seconds?
Sure. I would say this, especially to my Republican colleagues. We've got your back on this one. The weight of doing the right thing is with you. If you do this, we're there for you. This is not negative pressure. This is positive. We will back you up. You wanna come out and you want to be a part of this movement. We'll be there for you. We'll be shouting your praises, and you will help change the Republican Party and bring back something really positive that has always been a part of us, but lately hasn't seemed to be reflecting in the public sphere. Help me, and I'll help you.
Thank you, Steve. And Linda, we're going to wrap it up with you.
It's time to end sex discrimination. This is not a hard question. We don't want to have sex discrimination. I mean, the government can do lots of things. It can but it shouldn't be able to discriminate on the basis of sex. That's all. It's a very simple idea, and there shouldn't be any time limit on equality.
Well, thank you. I want to thank all the panelists, and I want to thank everyone for attending. Please also go to our website, www.eracoalition.org, for more information, and feel free to reach out with any additional questions. And I hope you all have a wonderful